They signed waivers. They knew the risks. But does that mean no one is legally responsible? When OceanGate's Titan submersible imploded, killing 5 on board, it wasn't just a technological tragedy. It exposed a chilling legal vacuum at the bottom of the ocean. Today, we dive into the legal black hole behind the Titan disaster and where the lawsuits could surface. Let's get into the legal aftermath, starting with the most controversial point, the waivers. Every passenger aboard the Titan signed one, multiple times. In bold letters, they were told they could die. In the recently released Netflix documentary, Titan, the waiver is even read aloud. This experimental submersible has not been approved or certified by any regulatory body. You could be injured or die. But here's the legal twist. Waivers aren't bulletproof. In U.S. law, they rarely protect against gross negligence or reckless conduct. Stockton Rush, OceanGate's CEO, had previously dismissed safety concerns, saying safety is a pure waste. Internal emails warned about potentially catastrophic flaws. That's not just risky. That may be evidence of gross negligence. So, could the victims' families file a wrongful death lawsuit? Legally, yes, but it's complicated. First, where do you sue? The Titan was launched from Canada, imploded in international waters, and operated by a U.S. company. That's a jurisdictional nightmare. Second, OceanGate declared bankruptcy. But what about Stockton Rush's personal estate? Could families pierce the corporate veil and hold him personally liable? That depends on whether courts find OceanGate acted fraudulently or recklessly. This case could redefine liability in extreme adventure tourism. Here's where the legal waters get murky. The Titan wasn't certified by any classification agency. OceanGate deliberately avoided oversight, claiming innovation was being stifled. In 2018, OceanGate's former director of operations, David Lockridge, was fired after sounding the alarm on safety issues. In a public testimony at a U.S. Coast Guard hearing, Lockridge said he believed a tragic incident was inevitable because the company had bypassed all standard rules. Because the dive took place in international waters, no single country had clear legal authority. Add in flags of convenience, where vessels are registered in countries with lax laws, and OceanGate's operations slipped through nearly every regulatory net. If a deep-sea vessel implodes and no regulator was watching, who is responsible? Even if legal liability is murky, ethical responsibility is glaring. Did OceanGate adequately warn its passengers of the extreme risks? Were they truly informed, or was the allure of adventure too strong? As we move into the era of space tourism, deep-sea exploration, and extreme adventure, the Titan disaster raises one big question. What legal safeguards should exist when pushing the boundaries of human experience? Waivers, wrecks, wrongful death? The OceanGate disaster isn't just a cautionary tale. It's a wake-up call for lawmakers, regulators, and legal professionals worldwide. If you're interested in how law intersects with innovation, risk, and tragedy, make sure to subscribe. We cover the legal stories behind high-stakes events, not just what happened, but why it matters. Should extreme tourism face stricter legal oversight? Let us know in the comments. Do you want to support the channel and get something useful in return? Check out the affiliate links in the description. Each click helps us to keep bringing you the news that matters.